you're watching Hindustan Times, and I'm Aditi Prasad. It was Tarun Tejpal on trial for the alleged rape and sexual assault of a young journalist at a five-star hotel in Goa. This was back in 2013. But the 527-page verdict, which was made public yesterday, 4 days after the Goa court ordered his acquittal, has raised the hackles of a large number of people and on a number of counts. First, the way in which the investigation was done, the judgment goes into how a lot of evidence was not brought on record by the Goa police and also suggests that some of the evidence may have been destroyed. Secondly, and more importantly, is the language of the verdict itself, which essentially puts the complainant in the dock. In several places, the complainant has been called unreliable, her behavior after the assault has been questioned, even her friendships and past relationships have come into question and have been put under the spotlight. In fact, 400 pages of the 527-page judgment have been used for dissecting the testimony of the complainant, eventually terming her as unreliable. Whether Tarun Tejpal was needlessly given a long rope by the Goa court is something that higher courts will decide. We don't want to get into it. The Goa government has also already filed an appeal in that case, but the judgment itself has raised several questions. One, can the burden of proof be shifted on the survivor in a criminal trial? Secondly, is there a behavior code that courts expect from survivors of such assaults? And finally, can a survivor's past behavior and relationships or conversations be used to determine such crucial cases? I have with me eminent legal minds to understand the problems with this verdict. We have Advocate Pinky Anand, very senior legal luminary, and Hindustan Times legal editor here with us. Let me start with you, Pinky Anand. A fast-track court takes more than 7 years and then delivers this sort of a judgment. What's your first response to this?
I mean, aside from the fact that, we are talking about speedy justice, and particularly in cases of sexual assault, and there's been so much of attention which has been paid on the subject as far as either civil society is concerned or media is concerned or even courts are concerned. Constantly, it's of course a complete controversy to have 7 years as far as judgment is concerned. But it was, the whole judgment itself is something which I think shocks you. For the reason that an evaluation of the judgment, of course, 527 pages is a long judgment, and I'm sure we can spend more time reading it, but as much as one has been able to make out from it, the whole discourse on the judgment appears to be as if there is an attempt to rip apart the testimony of the prosecutrix. I mean, it almost sounds as if she is in the place of the accused in a way, where the burden, because the burden in these cases, the burden of proof, as far as these cases are concerned, you're talking about a case of rape, you're talking about a case of sexual assault, you're talking about a case of wrongful restraint under the various provisions, is ultimately on the accused. And it has been very, in some fashion, been shifted by the concerned court to the prosecutrix, as if it is for the prosecutrix to prove that she is right. And if you just look at it, you look at whether the prosecutrix statement has been evaluated insofar as the incident is concerned. You're talking about the prosecutrix version regarding the various emails that she had sent. You're talking about the prosecutrix talking to her friends, to her mother. And every time there has been an evaluation, you feel, honestly speaking, that there is a bent of mind which wants to demolish. I'll be very, Aditi, I'll tell you very fairly, and Utkarsh, when we discuss a case, I'm sure it is always possible to find an argument both ways. But I to some extent here today we are talking about the kind of prejudices that you might have. And the prejudice in this case appears to be to look for flaws. And incidentally, in most sexual cases, it has been the finding of the Supreme Court constantly that don't look for minor contradictions. Please understand, a victim, when the victim is out in the open, A, there is a question of victim shaming. B, there's a question of employer-employee relationship, which is there. It's a workplace kind of situation, even though it's outside the workplace, but frankly, it was a conference, which was part of the work team. C, you have a situation where the victim is shattered. D, you have this evaluation as if a person is supposed to be sitting as an expert witness across testimony. Firstly, the contradictions are literally minor. I'm not saying there are no contradictions. And what are the contradictions? Are they worth it? Do they go to the root of the matter? Do they go to the root of the matter whether she's been sexually assaulted or not? Rape, sexual assault, whichever category you want to go to. I'm saying, and that part was not even discussed. Sexual assault per se, aside from rape, it's as if the case is only one of rape and been dealt with like that. So, I mean, the whole, as I said, the whole evaluation of the judgment leads you to believe that there was a certain thought process in evaluating that entire issue. Whether the prosecutor's testimony has been credible or not credible, corroborated, not corroborated, flaws, contradictions, in each of these manners, there's a complete display on that count.
Right, ma'am. And I will, let me just come back to you, but I just want to go to Utkarsh for a moment there. Utkarsh, can you, key highlights of the verdict in this case? You narrated it very well on your Twitter timeline. I saw that you had taken out all the important points and you had put it out. But can you just for the benefit of our viewers who may not know what the exact wordings of the judgment are, and especially the problematic ones, can you just take us through the key highlights of the verdict?
Well, Aditi, it's a very, very long verdict. It's a 527-page verdict, but it primarily deals and hinges on the testimony of the complainant in this case. Now, around 400 pages of that judgment has been used only to cite what the complainant had to say, and as Ms. Anand was earlier pointing out, to demolish the version of the complainant. Each and every sentence that she has said, that has been analyzed very, very minutely through a microscopic view. They are, and every minor contradiction, according to the judge, the additional session judge, Ms. Chama M. Joshi, according to all those minor contradictions, she judged and she held that they go to the root of the case. Whether she froze or not, what did she do while she was allegedly being assaulted, how did she react, she was a yoga trainer, what kind of friends she was supposed to have, not just that, which side her face was, where was her underwear, did she pick it up, did she pull it up, what exactly, all those kinds of words that have been used by the complainant during her testimony, all those, what did she do before she was assaulted, how much time did it take for her to go to the lift, to come to the ground floor, did she not know what kind of buttons are there in the lift, did she ever try and tell the police whether the red button, how was this possible that the lift can be in circuit, although the judge herself says that the police failed in investigating whether there was a system like this in that hotel's lift or not. Not just that, there were hotel employees saying that the buttons had been changed after this incident. However, that testimony has been thrown out by the court by saying that there is nothing to show that there was actually a button whereby somebody, a user of a lift, can put the lift in a circuit. When she came out, what kind of a dress she was wearing, what kind of underwear she was wearing, all these parts have been very minutely discussed by the judge to tear apart the credibility of the victim, of the complainant, and the judge also went down to put out in public domain through this judgment all her past relationships, experiences, endeavors, who did she meet, what did she mother do, what kind of relationship she had with other people, and not just that, the judgment also discloses her email ID and also her husband's
Yes,
name, which
you
is
mentioned a
impermissible
lot
under
of
the
things.
IPC.
Right, you mentioned a lot of things, Utkarsh, and I will go to them one by one. But Karuna Nandi also joins us, eminent lawyer. Karuna, welcome to the show. I want to ask you, if I were to ask you in this verdict, the verdict that has come, you obviously gone through it. It seems that the burden of proof has now been shifted to the survivor in a criminal trial. And as I was pointing out, that it seems that this is in Supreme Court actually set out just in March this year, had set out several guidelines on how courts should handle orders related to sexual crimes, right? One of the key points was the desire to find an ideal sexual assault victim ki ye aisa hona chahiye, should be crying, should be in a certain way. Supreme Court had said you should do away with these things. Now, just because this victim did not cry when she met her friend, when she exited the lift, or just because she, the photos, I'm just reading from the judgment, photos show the survivor to be absolutely cheerful and with a smile on her face and not disturbed or traumatized in any manner. should courts really acquit the accused if the survivor doesn't cry enough or doesn't go into depression? Karuna, I'd like to come to you with that question.
Aditi, the point that you're making is extremely important, that the Adarsh Nari is expected to be the Adarsh victim, right? Somebody who has somebody who has bruises in this judgment, not under the law, let me be clear, because this judgment purports to set the law back many, many decades. It seeks to do away with the explanation to Section 375, what consent means, the Section 53 of the Evidence Act. The previous one was a reference to the IPC. Section 53 of the Evidence Act of prior sexual history being relevant, etc. But let's come specifically to your point, that she wasn't upset enough. The judge also makes much of the fact that she knew a lot about rape law. She did a lot of stories and reporting on rape cases, and that she was intelligent, that she was intellectual. She seems to use these as negative words somehow, and
Somehow,
that
yes.
she didn't get a medical examination immediately, right? That she failed to not have a bath and to not kind of go about her business, and that she failed to go immediately and file an FIR, ignoring jurisprudence from around the world now, and also international guidance to police officers saying that classically rape victims take time to process what's happened to them, to gain courage, and to a post-justice system which, let's face it, has failed all rape victims in this instance, right? So was she wrong? But without prejudging the result, I think it's very important to look at the issues and the way in which these things are examined. The point that you make also about the fact that she wasn't upset enough, apparently, is a perfectly valid point and an important point. The fact that she took legal advice, I think Pinky ji will sort of support me on this, that whenever somebody makes a criminal complaint, of course we want them to have legal advice. We want them to have some hand-holding. We want them to make sure that they include all the truthful fact, the instances, all the relevant issues that occurred. So I just want saying that the fact that she made a call to Indira Jaising, who has been an ASG of this country in the past, the fact that she called the National Commission for Women, the fact that she was kind of gathering her resources to look at whether she should file a criminal complaint or not is bad. And you know something, in the Priya Ramani judgment, it's a different forum, it's a magistrate's court, it is true, but the legal principle laid down there is something that we must all remember. That where the criminal justice system does not across the board serve victims, a victim has a right, has a legal right to choose her forum.
Right. Do you think, there was, you said that, legal, you talked about FIR not being filed in time, that she being taking that much time.
She didn't actually file the FIR, but
yeah,
she filed a sexual harassment complaint.
Right. And when a sumo moto thing was taken by the Goa police. Now let's talk about the delay in filing of this FIR. It's another observation made by the court saying that there was no medical evidence on record to prove sexual assault because of this delay. Is that something that will set a precedent and deter women who want to report abuse or harassment if much time has passed? I mean, does that Karuna, would you want to take that?
See, happily, there are very strong precedents from higher courts that say very clearly, point blank, that the absence of medical evidence does not mean that there is an absence of consent. The problem with this judgment is that the judge has failed in all the many pages that she appears to have devoted to the young woman's flirtatious conversations. She seems to have forgotten about the key ingredient in cases of digital rape, which is consent. The key ingredient in the case of conviction under 354A, which is sexually colored remarks, which is consent. She has failed to recognize that Section 354A does not merely include unwelcome advances that are physical. It includes unwelcome advances that are oral. She has failed to add, in fact, in accordance with Justice Chandrachud's judgment of the Supreme Court, which says that at any stage, if the accused has had the chance to answer the substance of the accusation, you can add a charge. She has failed to add Section 509, words and gestures that outrage the modesty of a woman. She has failed, in fact, to look at the admission that was made by Mr. Tejpal in those letters. And she has dealt with them in a summary manner by saying that he was, under Section 24 of the Evidence Act, coerced. After recognizing, the one thing she has recognized is that there was a position of power, right? That here's an editor-in-chief, here is a young woman who is his daughter's age and indeed best friends with his daughter. She's acknowledged the position of power, and then she says no. He was coerced into speaking of these word non-consensual, right? Of
Right.
non-consensual. So why is she not convicted for 509 and 354A?
That's a very important point that you bring up, and I want to go to Pinky Anand with that. Pinky Anand, an apology was written by Tarun Tejpal in 2013, where he admitted a shameful lapse of judgment, quote unquote. He wrote that this lapse led him to attempt a sexual liaison with the survivor on 2 occasions, despite her reluctance. He's admitted all of that.
Not reluctance, non-consent.
Yeah. And that you did not want this. I mean, I'm quoting from his email, so that's the word he used. Now it seems that the court has just glossed over this. I would even just call it a semi-confession. Would you agree, or is this too much of a presumption on the part of a judge to say that this letter was written under pressure and under coercion?
No, I'll tell you one thing. For a moment, let's look at it in 2 aspects. Firstly, you're talking about the letter. The judge deals with it as a confession and then discards it as a confession on the ground that it is under pressure and coercion, etc. And that too because a letter was written to the editor asking him to atone or otherwise send an apology, failing which something would happen. So the entire discussion regarding this apology for a moment has been on the lines of a confession. Firstly, how can, for God's sakes, literally, such a letter where complete admission is made, whether of the sexual act itself or not, but of sexual definite coercing and definitely outraging the modesty, be discarded altogether on the count of it being under a pressure of whom, that to a subordinate. I mean, a subordinate writes to the editor, pointing out what the complainant or the survivor has actually put forth, asking explanations on those counts. The accused in terms apologizes. What is he apologizing for? That is the real question, isn't it? If you talk about the burden of proof, the apology has been made on account which is evident from the context of it. Now, whether it is a confession or not a confession is in its own way not even very relevant. The point is, it is a complete evidence on a fact that something untoward happened. That is the real criteria. So what more do you want in terms of either corroboration or admission or finding absence of consent, which Karna very rightly says the whole key thing is absence of consent. The question is not anything to do with what the survivor was doing, was not doing before, after relations, past days or future liaisons. The only question is, was there consent or was there no consent? Did some action happen which was untoward, which was forced on her without her wanting it? No, the question was also asked by the judge, saying that she didn't resist. She didn't forcibly push him away. She's a yoga instructor. I mean, what is all this about? Are you trying to judge whether her physical forces are supposed to be adequate to do something and therefore, and very right again, Karuna or Utkarsh, I don't know who had mentioned that, but the fact is that it takes a lot of time for a person to reconcile themselves into what they need to do. This entire situation happened at an event. This event was going on for several days. This was organized by the organization and there were thousands of people around. Now the question is, what is anybody going to do? Is a rape victim expected? And this is when again talk about the ideal rape victim. So according to what has been held in the judgment, The ideal rape victim should have come running out of the lift. She should have been crying desperately and howling
Yeah.
away. They have immediately rushed to the police station and gone and lodged a complaint there, failing which it is otherwise. And these kind of assumptions are what really puts us to shame. I'm sorry. But
And
is this concern that you have for women, that you will discard their testimony on kind of, you're taking it threadbare and saying, oh, she walked out. No, she went in 2 hours at 12:30 a.m. She talks to the person concerned in the firm. I don't want to name everybody,
yeah,
even though the judgment names at all, I'd much rather stay out of that. But she goes and confides to a friend. There's another friend who testifies. There is a mother whose testimony is there. They all mention, frankly, even though I don't think I should, but they do mention that she's distressed and crying desolately. What do you want? What do you want in confirmation of that? You may have other counts, but this ideal rape victim, which is by now totally discarded by the Supreme Court, in terms, just about a month and a half back, we were talking about this judgment, and I
yeah.
was saying that this judgment is going to pave the way for the trial courts and the other courts below to actually
Clearly, no
follow.
lessons. Clearly,
And
no lessons have been taken.
no lessons are being learned, then where do you go from there? We hope that when the Supreme Court comes down so heavily and puts down a complete platform and puts down a complete card ahead of you to say this
Right.
is what should be kept in mind. We've had earlier instances where somebody said, oh, the victim went to sleep. She couldn't have gone to sleep. Another case which says that she didn't sound desolate and therefore not the ideal rape victim. And again, what they say, oh, she was very forward, or she was drinking, or her clothes. I mean, you are not going to go into these domains. Either
Yeah, so
something.
there is no adarsh victim ka jo ek, I mean, yeah, that's as you were pointing out just now. There's no adarsh victim, and that is what the Supreme Court also tried to make people understand and make the other judges understand. But this
Not only
judge has done exactly.
Aditi, sorry, it's not only Adarsh
Yeah,
victim. You can't put it into a patriarchal mindset and say this is what a woman should be and this is what the
should do.
victim has.
Absolutely.
Anytime you
That
step
she
out of
needs to
line,
try.
the finger
Right.
will be pointing at you. It cannot be. You may acquit, you may convict. That's quite another matter. But you simply cannot take apart a complainant on the ground of her behavior, dressing, any kind of liaisons that she may have had in future. We are into different times, for God's sakes. I'm not saying praise her, by no means. But you cannot rape her in a testimony on this ground.
Which is what our Bollywood movies have shown us through the years, ma'am, that how victims of rape are not just raped once, they're raped again and again by the system at various points. And this seems, I mean, I thought we're in the 21st century now, but clearly no lessons, no understanding of how to deal with such cases is there. Equally questionable perhaps is the court's view that the survivor may have doctored her initial statement after speaking to lawyers and eminent lawyers like Indra Jaising and Rebecca John, etc. So, but
To talk
let's
to lawyers, Aditi, is a matter of right. We live in a country where
absolutely.
the right of a person to have legal counsel, and every complainant, everybody who has a problem will go to a lawyer, should go to a lawyer, and there is no question of it. The questions. Sorry, I mean, of course, Indra and everybody being senior most definitely, but any lawyer, you have a right to counsel. You can't be denied such a right. And pointing out fingers and saying, you went to National Commission or you go to X or Y or Z is the absolute absurdity on the face of it. You
Right.
cannot be
Karuna,
denied this rule of law.
right. I just want to move a little away, Karuna, and I'm going to come to Karuna and then I'll come to you, Utkarsh. Let's talk about the survivor's privacy. Now, the judgment in this case really talks about her past relations, her WhatsApp chats, and her past messages with friends are quoted to say that her messaging records show that it was entirely the norm for the prosecutrix to have such flirtatious and sexual conversations with friends. Now, how is that relevant in a case in the present case? This seems like a blast from the past. As I was just saying, it reminds me of some old Bollywood film where a victim is raped again and again by the system.
I'll let Utkarsh take this first. Your thread on Twitter was really excellent, Utkarsh, and you read the judgment very carefully. Why don't you go first and then I'll follow?
Thank you, Ms. Andi. So I just want to say that the prejudice that the bias that this judgment shows about these past conduct, as you also said it, Aditi, at the very beginning of this show, that in March itself, Justice Ravindra Bhatt, writing for the three-judge bench, handed out a checklist for the trial judges, judicial officers, that these are things that you can't talk about when you're dealing with a case of sexual assault or a rape. You can't talk about past behaviors. You can't talk about her past relationships. You can't talk about her drinking and other habits. These are all, the court called that this misogynist attitude. They must be given away. They must be done away with by all the trial courts. However, despite all that, words of caution by the Supreme Court. 2 months ago, we can see a judgment in which her past conduct has been now brought on record, just to tarnish her reputation and to say that she is somebody who was used to it. She was somebody who was used to having such conduct, and therefore her testimony, to the extent of saying that what she was, that she might, what Mr. Tejpal, as an accused, is right in saying that this was all about a conversation that he had with the complainant, because she was used to having similar conversations with many other people. All her past relationships, her relationships with friends, and the WhatsApp chat, everything has been put out in public domain. And now we have a judgment in which a victim is now scarred for the entire life. It takes a lot of courage, as Ms. Nandi said and Ms. Anand said, it takes a lot of courage for a victim to come out in the open, to to
Yeah.
uh, to, to stand up for her rights, and to stand up to say that I was ravished, I was sexually assaulted by somebody who was in the position of power. Now, as Ms. Nandi was earlier pointing out, the atonement email, while you have the accused saying that I unconditionally apologize, the trial judge reads some kind of coercion into it. The email never talked about the fact that I'm recusing for 6 months because I wanted the inquiry to be neutral, but somehow the judge reads that also into the same email, that the recusal was only to facilitate the independent inquiry. So these are implications, they are very convenient inferences drawn by the judge at various junctures, at various places in judgment, just to say discredit the victim. And as Ms. Anand earlier pointed out, it is not just about the outcome of the verdict. There could have been acquittal, there could have been conviction, and we can see many cases in which a rape case might lead to an acquittal. But the manner in which the judgment has dealt with the issues, the manner in which it does not empathize, the manner in which it deals with the testimony of somebody who had the courage to come out and stand up to stand up in a court of law to prove that she was assaulted. Now she was the one who has been now been made into an accused of, because of all these past relationships, because of what she had to say. And perhaps today and tomorrow there will be a remorse on her part. This will be somehow, this is going to be more rape victims will feel feared after reading this kind of judgment. Even molestation victims, they will have a fear to come out and complain against their assaults if these judgments were to be upheld. And the manner in which it is written is something very, very serious, very grave, the manner in which the judge has dealt with the issues.
Karuna, I want to ask you, based on what Utkarsh pointed out, all of these things are now in the public domain. These are not; they are part of the judgment. Her WhatsApp messages, her texts, names of her friends, her husband, this. I mean, this complete her life is now open in front of everybody. Do you think that this is going to be serve as a deterrent, huge deterrent for survivors to report cases, because now everything is out in the public domain, and just because she's had conversations previously with friends which were flirtatious and of a sexual nature, so therefore now she can't be uh, uh, you know now she's being, there's a moral judgment being passed on her here.
When I have, when I represent rape victims and victims of sexual harassment in court, there is a huge apprehension on their part. And the ones that last the cause are the ones that have a very clear sense that they must fight for justice, not just for themselves, but for others. Unless they have that sense, my experience so far is that what it takes is something that the vast majority of people who experience
Never
sexual assault don't have the bandwidth to take it through. When you have someone who didn't complain in an FIR in the first place, right? But when it went through, she stood up and she put her life as an open book on the line with the faith that the consent, her non-consent, would be honored. The fact that in this judgment, the court has not only displayed a very, very serious, and I use this word advisedly, ignorance of law, but has also violated Section 228A of the IPC. So she's displayed ignorance of the law on the one hand, which is something that a superior court can reverse, and also perhaps that can be fixed in training, perhaps suspension for some time, and some time at the National Judicial Academy, where I have conducted trainings on 2 trainings and 1 on gender justice. So perhaps retraining could be done. But she's also violated law, right? 228, which is something that the average citizen would be imprisoned for. Let's be clear, right? So now what I'm saying here is that yes, it is a deterrent, but in purely legal terms, what there is a deep misunderstanding also of what the law is. So for example, Section 53 says that if it is a good character might be relevant, right? So if she had said that, look, I have good character and therefore this could not have happened to me, then the door would have opened to cross-examination to say that, no, you don't have good character and this is what we consider bad character, so we're going to cross-examine you on it. That is not what happened. These people brought up all sorts of other communications implying that because she drinks tea every day, somebody forcing her to drink the tea is all right, right? Also, if you see, there's another huge mishandling of a piece of evidence by the court, where much is made of the fact that the prosecution didn't have and ergo destroyed the CCTV of the CCTV footage of the woman and the accused, the prosecutrix and the accused, leaving the lift on the first floor where Robert De Niro was staying in order to give him a message, right? Why does she say this? If this was on some substantial basis, then it's something that would be extremely serious, regardless of whether or not there's acquittal, regardless of guilt, regardless of anything. Because it means that if you're destroying evidence, exculpatory evidence or not, then obviously the police officer should be pulled up. And I would say, given that a sessions judge has actually made this allegation, maybe some investigation should be done.
Absolutely. As far as the
to get rid of the allegation. But let me just finish. She says that the DVR had footage of the first floor. Now, if you're an investigating officer and somebody enters the lift on the ground floor and then exits the lift on the second floor, and the first floor only shows a closed door, and these are all different DVRs, keep in mind, right? And DVR has hundreds and thousands of hours of footage. It's not that it's kept endlessly. Like, I've argued a case, a criminal matter, where the DVRs were wiped every 3 months, right? In a normal course. In CCTV, every single moment is recorded, right? So if you see that the lift door is shut and you don't then take it into evidence, and then in the normal course of things that evidence is destroyed, or it's not evidence, that the CCTV footage is destroyed, then only on the basis that Mr. Tejpal in his wisdom has said that actually during those 2 minutes, I came out on the first floor, I and the prosecutrix, we went to Mr. De Niro's room, presumably to give some message, and then we came back, not adducing any further evidence on it, that then gives rise to the presumption that the state prosecution has destroyed evidence? That's a very serious thing to say. I'm still saying that if the allegation is made, to the investigation, clear that officer, if he is to be cleared, or if she is to be cleared. But that's a very serious thing to say. I also want to make one last point, Aditi, because I sense that you're wrapping up. I just want to make one last point. The BJP state government and people who support women's rights are very much on the same page on this. And I think that's important. It was also this case in the Triple Talaq case. It's also been the case in a large number of other cases. But I also want to point out that there is a double standard in governance. That when it's somebody like Tarun Tejpal, the entire state machinery will go after him. Well, the ASG appeared in the, I'm not the ASG, sorry, the Solicitor General, the learned Solicitor General appeared in the Bombay High Court. But what happens when it's a Kuldeep Singh? What happens when it's a child rape in Kashmir? I think that it's very important to apply these principles of women's rights across the board, regardless of political persuasion.
And it's not just women's rights, it's rule of law should be the same for everyone. And I concur there. But as far as coming back to the case that we are on and the topic that we're discussing right now, and I want to really, and you're right, Karuna, I do want to wind up because you've taken a lot of your times already. But I just want to take last thoughts from you on the judgment. Of course, leaves a lot of open ground for appeal, which has already been filed. Goa government has filed an appeal in the High Court, right? That's already happened. Do you believe that Tarun Tejpal, what next in this case? What is your sense? Where is this case going? He's been acquitted. A conviction seems like a possibility. Going by what you know about the case so far, what's next in the case?
I'm not a soothsayer, but let's look at the facts as they stand, and then I will attempt a prediction. In the next 3 days, the government will file additional grounds that have emerged from the concrete judgment itself, right? Because earlier, the sessions judge just gave her judgment without giving any reason and without actually publishing the judgment, which is also a practice actually that is being discouraged by the higher courts. So the government will file the grounds, and I think those grounds, I'm sure they'll actually be good. And in any case, the High Court has the ability to go into the judgment and look at what there is to say. And the Victims' Council, I'm sure, will be represented to assist the government also in court. With regard to the evidence that's already on record, you have, I think the High Court will evaluate that despite the Sessions Court's vilification of the prosecutrix's character, were the discrepancies in her testimony material, or whether that's just normal, right? Given the time that passes between your 164, between your examination in chief, etc.
Agreed. So that's what's going to.
But there's concrete evidence on record, I think, that there's more than enough evidence to convict for Section 354A and Section 509. 509 she didn't include. Section 354A includes sexually colored remarks that are short of touching, and I think there's more than enough evidence to convict for that.
All right, Pinky Anand, I want to come to you. I want to talk about the verdict per se and the wordings of the verdict and what kind of precedents they set. Do you think there will be some sort of taking back of some of the kind of words and some of the observations that have come out? Do you think there is a case for an appeal here too, as far as the wordings of this judgment are concerned, and in the larger context of women's rights in this country, and in the larger context of encouraging other women to come forward and file reports and file sexual abuse reports?
You are right, Aditi. I think what you have mentioned out on the first note itself, even in today's hearing, in the appeal, there was redaction ordered as far as the disclosure of the sexual identity, or rather the name and various other details of the survivor. That by itself is one of the biggest ignominies that can happen as far as the judgment is concerned. But in addition, it has been known, it has been seen that particularly in the recent judgment which came against the Madhya Pradesh High Court judgment, which dealt with a variety of statements which were highly objectionable and literally struck down. So there is a tremendous amount of scope for that. I also want to add, Aditi, one thing that I was just talking about. When I was going through the judgment, I was trying to find that particular line. I couldn't locate it offhand. But I do know that Tarun Tejpal had asked for the records of the lift and the CCTV, etc. And at one point, he didn't ask for it. This is recorded by the court, by the way, itself. As I said, I couldn't find the exact line. It is there. I marked it out. So it is actually fascinating. but really the approach of the court. I think what I am confident will happen either in this court or another higher court, that ultimately you do have to set the benchmarks as to what you can do in a judgment and you can't do. In cases of social crimes, these are not individual crimes alone, as you rightly said. This sets up and paves the way for people, not only for themselves, for others. Imagine a person who's in an employer-employee relationship, in a working relationship. You're talking about women in workplaces, protecting them, and Bhavari Devis and whatever came up during the course of law, and you allow them to be literally rattled, shaken, pummeled by, if not physical actions, whatever may have happened there, but by words on characterizations alone. I think that is something which will definitely be set right at some level of this rule of law that we do have, because it has been done. Recently, they said the Supreme Court had come down on this ideal women thing. It hasn't obviously worked in this case because, again, as I said, and we all agree on this part, you may have a judgment for or against, but you do not have it on these counts. You have a victim, you have a prosecutrix, she makes a statement where she differentiates between pull and pick, and that is made about 100 paragraphs on that kind of statement just to show the discrepancy, so to say. The point is really not that. Was she outraged? Was she raped? Yes or no? If her statement sans medical testimony, and incidentally, again, courts have held consistently, medical testimony is not required. You do not require corroboration. What happens behind closed doors or closed lifts is not evident for anybody to see. There is no direct proof of it. It can only be taken by and large on what happened, but you cannot for sure discount it based upon how she behaved before or after.
Right, whether she was smiling after, or whether she cried when she met with her friend, or did not cry when she got out of the lift and faced with the way, that certainly cannot be evidence. It seems like you're doubting the survivor, but you're giving the benefit of the doubt to the accused in this case. So I'll leave it there. It's for the higher courts to now take a call and understand exactly what they need to do, whether how they will take it up. It's set for hearing soon. So we will keep bringing you all the latest updates in this case and the analysis of what's happening. Thank you so much, Karunanandi, Pinky, Anand, Utkarsh. Thank you for joining us today. We look forward to meeting you again soon on this platform. Thank you, viewers, for watching this broadcast. We'll keep coming back to you with more. Stay tuned to Hindustan Times.